the part heard appeal in the matter of South Bank for Management Company Limited and Galliard Hotels Ltd and others.
Mr. Scotland.
My lady, my lords, I'm grateful. I intend to address your ladyship and your lordships on the 4 issues arising in relation to the room leases claim in the same order that learned friend Mr. Porgadiri addressed you. Those are, as you recall, 1, whether clause 9 included an obligation. 2, whether, if so, the obligation was a continuing obligation. 3, whether, if there was a continuing obligation, the grant of the lease represented a continuing breach of that continuing obligation. And then 4, whether South Bank in any event suffered any loss by reason of the grant of the lease. And for South Bank to succeed, it also obviously needs the court to determine each of those 4 issues in its favour. So the first issue, that's respondents ground 2. The judge erred in law in concluding that clause 9 of the room lease contained or included an obligation on the part of Galliard Hotels, which might be the subject of a contractual claim on the part of South Bank. That room lease claim is premised, of course, on clause 9, including an obligation. If one could turn that up, please, at supplemental bundle, tab 2, page 22. My lady, my lords, have been shown this before, of course. The landlord hereby grants to the company the right to utilise the common parts in conjunction with its appointment by the tenant in clause 8 hereof for the purpose for which they're properly intended. My short submission here is that there is just no way of reading the words of clause 9 so that it imposes an obligation on Galliard Hotels. It is in the nature of an immediate grant of a right, whether contractual, proprietary, contractual, overland retained by Galliard Hotels. And I say that's the only possible construction of clause 9, necessarily so by the words hereby grants. It's simply a grant. It's not a promise to do so in future, it's just a grant.
So what does that mean?
Well,
you're going to come to that, are you?
well, my Lord Justice Newey made 2 observations in the course of Learned Friend's submissions yesterday and the day before, which I'd like to deal with, if I may, now, maybe the ones my Lord was interested in. And those were to the effect that even if clause 9 imposes no obligation on Galliard Hotels, I think my Lord's words were, that doesn't mean it was entitled to obstruct the right in clause 9. And then yesterday, my Lord Justice Newey observed, it might be thought that what we're dealing with here is a covenant for quiet enjoyment. I think those might go to the same point effectively. Well, the respondent's response to those observations, insofar as they invited one, was and is that that's not South Bank's case. And what you haven't been shown yet, perhaps conspicuously, is the pleading on the room leases claim. So if we might turn that up, please. It's the re-amended particulars, core bundle, tab 10, page 187. And at as paragraph 15b. 15b itself pleads both clause 9 and the common parts definition. My Lord may recall the judge found that the common parts included the annex. 15c refers to the plan. 15d pleads that the annex fell within the common parts, and that that clause 9 was a right to use without paying further consideration, entering into further agreement. That, I say, is simply a description of clause 9, the right granted. One then has in the final sentence of paragraph 15d the exercise of the right granted in clause 9 from the date of the room lease till the date of the lease, capital L, 16th of June 2008. And then for your reference, the judgment at paragraph 4 records, so core bundle 661, that the hotel opened in early 2008. The agreed chronology at core bundle 447 agreed that date, the 1st of February 2008. If one returns to 15E, that alleges a breach of clause 9 by the grant of the lease, and then 15F pleads the allegations of continuing contractual obligation, continuing breach, and how South Bank puts its claim in damages. What one doesn't see in paragraph 15 is any plea of any implied or express covenant for quiet enjoyment, or any allegation of breach of such a covenant. What one also doesn't see in in paragraph 15, is any plea of any implied or express covenant that Galliard Hotels wouldn't derogate from its grant of the right in clause 9. The only clause the room lease relied on is clause 9.
I mean, when I referred to the covenant for quiet enjoyment, I wasn't saying this was a covenant for quiet enjoyment. I was saying it was akin to one, or might be thought to be akin to one.
Well, in my submission, my lord, respectfully, it's not. It's the grant of a right. A covenant for quiet enjoyment might be separate and might accompany this, but that's not the covenant that they rely on. They rely simply on clause 9.
So what is the content of the right? What does the right mean? You've granted a right to use the annex.
Yes.
That's day one. Day two, you obstructed. Are you in breach of the grant?
You're not in breach of the grant.
So what are you in breach of anything?
A different covenant, potentially, for derogation from grant or quiet enjoyment.
So to be clear, day two, you've obstructed the right that you have granted.
Yeah.
Does South Bank have any right to complain about that?
Well, it might do under a different covenant. I suppose the short point I'm making, I suppose you might characterise as a point on what South Bank's case is. You might describe it as a pleading point. The point they are, or the clause they are relying on, does not afford them the relief they're claiming and does not give rise to the obligation they suggest it does. The clause itself, without further plea, is simply the grant of a right.
Within 15F, they say it was a continuing contractual obligation. That's their way of pleading what we're talking about, isn't it?
But no doubt they say that.
Yes, but and what do you say about that wording?
I say that clause 9 includes no obligation at all. It is the grant of a right, and that the continuing contractual obligation is a misunderstanding of what clause 9 does. Clause 9 grants a right. There may be a different covenant which they've chosen not to plead or rely on.
Now, I think Mr. Bukadiri says, well, if there's a right, there's a correlative duty. Do you accept that?
Well, I would accept that one might rely on a different covenant or a different contractual duty to establish a breach of that different contractual duty. And I can quite see that in this case, it might be said that having granted the right, Galliard Hotels, it would be subject to an implied obligation not to derogate from that grant. See that it might be said, but that's not South Bank's claim.
Yeah.
And I should say, this isn't new in a way. All of this was denied on the defence. We denied that clause 9 included any such right. There's no reply to that or amendment to answer the point we were making, and that's where we were at trial.
Yeah.
My lady, my lords, this is dealt with in judgment paragraph 376. That's at core bundle 6139. And then if one looks on at 377, what the judge does is reject what is now my and what's our trial opposition on the content of clause 9. It says that it's at odds with an ordinary interpretation of clause 9. He doesn't say there, respectfully, what the ordinary interpretation is. He continues that South Bank's complaint in this case is different. it argues that Galliard Hotels' very act of granting the lease impeded Southbank's ability to exercise the right it had been afforded pursuant to Clause 9, since it was no longer in Galliard's hotel gift to allow it to use the annex. If that complaint is made out, I do not see any secure basis why Southbank should be precluded from making a contractual claim for breach of Clause 9. So the judge does focus on the claim being for breach of Clause 9, but in my submission he fell into error, respectfully, when he concluded that that obligation, there was any obligation in that clause. And what the judge is describing there is akin to what my Lord Justice Newey and my lady have described as what effectively should have been Southbank's claim, or could have been Southbank's claim.
Can I possibly go off on a red herring for one moment? Suppose it was an actual grant of an easement. Suppose you have a document where somebody says, "I grant you the easement."
Yeah.
Now, that doesn't mean the grantor has to keep up the track or whatever over which the easement has been granted, but they're still not entitled to block it. And if they bring a claim for breach of the interference with the easement, that's good enough, isn't it?
Well, in my Lord Justice Newey's example, that would be a claim for nuisance, effectively disturbance of an easement.
Wouldn't it be a claim in contract if you have the original parties to the easement? Why wouldn't that be a breach of contract?
Well, it might also be a breach of contract. But here, whichever way one characterises it, what one is describing is a derogation from the grant of a contractual right, which is not what their claim is. Or here, in my Lord Justice Newey's example, the disturbance of an easement. It's a contractual claim is the way it's put, but the contractual claim here doesn't contain an obligation. In my Lord Justice Miles' example, you'd have to have a contract that provided that we wouldn't do what we've done. Here, the contract simply provides that we grant a right. There's no implied term relied on in paragraph 15 of the particular claim. There's simply a reliance on the wording of Clause 9, the express right, as I say, they say obligation in Clause 9. So it doesn't give rise to a breach of contract on the facts of this case. Not without more.
I mean, better let you move to your
So I think
point
that is my first point. You have my submissions on that.
Yep.
My lady, my lords. So the second issue, that's the respondents' ground 3, whether or not there is a continuing obligation, if there's an obligation at all, in Clause 9. That's dealt with in Judgment 380 and 382 at Core Bundle, tab 6, 139 to 140. You've been taken already to the Bell case. If we could just turn it up, please, at Authorities, Volume 2, tab 23. You recall that the claim for professional negligence against solicitors arising from divorce settlement brought in contract and in tort, arising out of the arrangement that they were or were not to be put in place in connection with the transfer of the party's former matrimonial home into the wife's sole name. If one turns on to 443, Lord Justice Nichols deals with the claim for breach of contract. He addresses the failure to take steps to protect the interest at 500 G. That was the steps that should have been taken in 1978. Holding that's when the breach occurred. He goes on to consider whether the solicitor had any further obligations at 500 G to H. To invite my lady, my lords, to just read down that last paragraph. So it's at H, or around H. Despite this, it was in 1978 that the breach occurred. Failure thereafter to make good the omission did not constitute a further breach. The position after 1978 was simply that in breach of contract, the solicitor failed to do what he ought to have done in 1978, and year after year, that breach remained unremedied. I'm just reading on. Failure to make good his existing breach and contract on request would not have constituted a further breach of contract. It would not have set a new 6-year limitation period running. Once again, the position would have been simply that the solicitor remained in breach, nor finding his position any different because in respect of a lodging caution, the breach remained remediable in 1976 when the house was sold. Remedial breach is just as much a breach of contract when it occurs as an irremediable breach, although the practical consequences are likely to be less serious if the breach comes to light in time to make remedial action. Were the law otherwise, in any of these instances, the effect would be to frustrate the purpose of the statute's limitation. It would mean that the breaches of contract would never become statute barred, unless the innocent party chose to accept the defaulting party's conduct as repudiation, or perhaps performance ceased to be possible. One then has the passage at C to E that you were taken to yesterday. And that's the passage relied on by the judge in 381 of the judgment. So the first point is that in my submission, Lord Justice Nichols is considering a contract that contains an obligation on parties to perform. So that's not obviously this case. What the judge says is that 382 Galliard Hotels obligation was to grant a right to utilise the common parts. You have my submissions on that already. He then moved to characterise that obligation as either a one-off obligation or a continuing obligation, and he concludes that it is a continuing obligation. I say there are two reasons why, with respect to the judge, he fell into error reasoning that way. I suppose I trailed them already by now. The first is that it's obviously premised on the proposition that Clause 9 contains an obligation. But again, secondly, what the judge appears to be describing in paragraph 382 of the judgment is something else. It's a different covenant. But even if one could characterise Clause 9 as an obligation, I say it's clear from Bell that it's not a continuing obligation because it's not one which arises for performance day after day. And I say this because once you've granted the right, there's nothing left to do. The right has been granted. That's not a continuing obligation, if it is an obligation at all. It's been granted, it's been met. There might be a separate issue over whether you've done something else.
What have you granted?
A right to use the annex.
But that must mean continually use the annex. It can't be for 1 second.
No.
So it must mean it's a right to use the annex and continue using the annex.
Yes, the grant of the right is to use the annex. I will accept that.
To carry on using the annex, not just for 1 second.
No, I also accept this not just for 1 second, that the right continues for the term of the room lease. I don't disagree with my lord there. Where I depart is that the complaint is about something else. It's about disturbance of that right in reliance on a different obligation or duty, different cause of action. So that, I say, are reasons why the court ought to conclude that if there was any obligation in Clause 9, the judge erred in concluding that it was a continuing obligation and his decision ought to be upheld on that additional ground. Moving then to the third issue, if I may, that is the appellant's ground 2, continuing breach. And their contention is that the judge erred in law by finding that the breach of Clause 9 was not a continuing breach. This is addressed in the judgment at 383 to 385, it's a Core Bundle 6, 140. We say the judge was correct to reject Southbank's contention that the grant of the lease was a continuing breach. The first reason for that is that, in my submission, a continuing breach requires some sort of repeated activity, continuing day after day on a regular basis. And we say that support can be found for that in the Jalla decision, aspects of which you were taken to by my learned friend. That is at volume 4 of the authorities bundle, tab 53. I don't think I need to go through the facts of that case. Reasonably well known, following my own friends' submissions. The issue in that case was whether there was a continuing private nuisance such that a continuing cause of action accrued on a daily basis for as long as the alleged oil damage had not been remediated. And thus the limitation began afresh from day to day. And I think it's worth recalling at this juncture that it was assumed for the purposes of the appeal that there was still oil that was on the land and hadn't been cleaned up or removed. There are two reasons my learned friend said that Jalla didn't help me. The first, he says it was a nuisance case, so it doesn't take matters anywhere in their contract claim. And secondly, he says it doesn't establish that one needs repeated activity for there to be a continuing breach, because he says there's an alternative formulation in Lord Borough's judgment of an ongoing state of affairs. I have both those points in mind. I'll pick them up, if I may, as I go through the judgment. Can I take my lady and my lords first to paragraph 24? It's at page 1654. So Lord Borough says that part of the difficulty in articulating what's meant by continuing nuisance for the purpose of the sort of private nuisance is that, as a matter of ordinary language, one can naturally describe the effect of the interference or damage still being present and not having been cleaned up or otherwise dealt with as being a continuing nuisance, in the sense of it being a continuing problem. I say that's an instructive insight. In this case, therefore, one can naturally describe the oil still being on the claimant's land as a continuing nuisance, but that is wholly misleading when one's trying to clarify the meaning of a continuing nuisance in the legal sense. That, I say, effectively is South Bank's complaint, is that the lease is still there, it's a continuing problem, but that's not the same as there being a continuing breach. If one skips on, please, to 26. This is the part, of course, we rely on. A continuing nuisance is one where outside the claimant's land, and usually on the defendant's land, there is a repeated activity by the defendant or ongoing state of affairs for which the defendant is responsible, which causes continuing undue interference with the use and enjoyment of the claimant's land. For a continuing nuisance, the interference may be similar on each occasion, but the important point is that it is continuing day after day on a regular basis. The Hole and Chard case is referred to in 27. My learned friend didn't take you to it. The summary there probably suffices. I say that was a case that was obviously a continuing nuisance where the defendants continued to discharge sewage, etc., into a stream flowing through the claimant's land. One just skips on to 31. And the second sentence there, the first Lord Borough says, additional point is that a continuing nuisance is in principle no different from any other continuing tort or civil wrong. So I say that that is an answer to my learned friend's first contention that this case doesn't help the court. I say it does. In principle, there's no reason between the analysis, there should be any difference in the analysis in relation to nuisance or any other civil wrong, including the breach of the contractual obligation in question. Burroughs tells us that, but nuisance, of course, includes an act or omission which is an interference with or disturbance of a person in the exercise of an enjoyment of a right they have, which is used in connection with land. The complaint here is that we have a breach or interference which South Bank is granted by Clause 9 over the common parts. And one actually might observe that South Bank's complaint now, as I've already trailed, is in substance akin to, my Lord Justice Newey observed, akin to the disturbance in the context of an easement. And that, of course, is a nuisance claim in substance. So that's, on the contrary to what my learned friend says, why the analysis in Jalla is of obvious application in the present case. And if one picks up, please, at 34, where Lord Burroughs considers whether there is a continuing nuisance in Jalla. It's at page 1656. says the essence of the submission is that there's a continuing nuisance in this case because on the facts that should be assumed for the purpose of this appeal, the oil is still present on the claimant's land, does not be removed or cleaned up. That's the point I was keen to press earlier on the facts. Then at 37 and 38, contrary to the submissions of Mr Siegler acting for the claimants, there was no continuing nuisance in this case. No continuing nuisance in the example of the one-off flood because outside the claimant's land there was no repeated activity or an ongoing state of affairs for which the defendants were responsible. Just pausing there, on the facts, of course, there was still the oil on the land, but that was not an ongoing state of affairs. Learned Friend's submission was that ongoing state of affairs is to be understood where one doesn't have repeated activity. The submission was to that effect, and he points to the Delaware case that's referred to in Delaware Mansions, that's referred to in Jalla. That was a case about a tree, the roots of which were causing subsidence to the claimant's land. In his words, Learned Friend's words, the tree was just there. As such, was an ongoing state of affairs for which the council was responsible. But that, with respect, doesn't appreciate why a living tree and its roots constitute a continuing active nuisance. They are continuing to dehydrate the soil, and one can see that at, for instance, 24 in Jalla. So sorry, not 24 in Jalla. 23. Just between G and H, the citation from Lord Cook of Thornden's judgment. The encroachment of the roots was causing continuing damage to land by dehydrating the soil and inhibiting rehydration. So something was still repeatedly happening. And one gets it also too from paragraph 38, Lord Burroughs' judgment, where he describes, this is page 1657, ongoing state of affairs outside the claimant's land constituted by the living tree in its roots for which the defendant was responsible, which by further abstraction of water through the encroachment of the roots caused continuing undue interference with the use and enjoyment of the claimant's land. So as I say, the second reason why Jalla does help us. Ongoing state of affairs to the takes Learned Friend, no further, it simply is another example of repeated activity on the defendant's land interfering with the claimants.
But in 38, Lord Burroughs seems to call it an ongoing state of affairs, the tree case.
Yes.
But rather than a series of events, as it were.
But that, if I may, I think is because of the, I mean, the tree is, as my learned friend put it, the tree is the tree, but it was and its ongoing taking of water from beneath the soil and causing subsidence was an ongoing state of affairs for which the defendant was liable, albeit the defendant wasn't causing the act itself, wasn't repeatedly doing something on the land. It was an ongoing state of affairs for which the defendant was responsible, the ongoing state of affairs being the repeated taking of water by the tree roots from the soil.
Yeah, so the idea of the ongoing state of affairs seems to be that when they say it's something for which the defendant is responsible, the contrast in this case seems to be that once the oil has all escaped, it's no longer on the defendant's land, and as it were, there's nothing more it can do about it. And in the case of the tree, it's an ongoing state of affairs, something happening on the defendant's land, which is causing damage to the claimant. That seems to be what's meant by ongoing state of affairs for which the defendant is responsible. But here the claim is that there was a continuing breach in the sense that they weren't able to have free access to the annex, and that is something brought about by the defendant to this claim, and the defendant continued to be unable to give that access.
Well, my lord, the allegation is that clause 9 was breached by the grant of the lease. That's the.
Well, there are two allegations, I think, in the pleadings you took us to. One was that, and then it says there's a continuing breach of the obligation. It says it was first breach. The word it used is first breach by the grant of the lease, and then there was a continuing breach, which must mean, i.e., by not having free access.
Well, the not having free access was caused by the breach. There are then no further allegations of what the defendant did or didn't do.
I mean, there is a sort of supplemental point there. If we get to this point in the argument, we have concluded that there was a contractual obligation on the part of your client on a continuing basis to provide access to the annex. And you made it difficult to achieve that by granting the lease. Now, actually, you could, on a continuing basis, have remedied that by getting the lease back. Well, I think it depends on you. I mean, Lodgeshine is not a subsidiary of you, but at the same time, you're all in the same group.
Yes. Well, I suppose the first point is what is pleaded, and I say it's the grant of the lease, and there are no further particulars given of the events that, or any further acts relied on, whether it's causing a surrender or whatever it may be said now, Lodgeshine ought to have done. Sorry, it was Galliard Hotels ought to have done. But not having, I mean, to the point made earlier, not having free access or ongoing access to the annex is, in a sense, the point I was alluding to, paragraph 24 of JALA. That's not the breach, that's the continuing problem. And that's the devil here, that's the mischief that one has to avoid, is the difference between the breach and its effect.
Yeah.
Is this point really different from the second point, which is whether there's a continuing obligation? That's the way that Lord Justice Nichols seems to have seen it in Bell. You look at the nature of the obligation. If it's a continuing obligation, then if it's being breached, it's a continuing breach. If it's a normal, what he calls a normal or usual breach of contract, it's a one-off. But he seems to see the two things as going hand in hand, and I can see some force in that.
I'm sure I necessarily accept that, my lord. In the present case, one might well have a continuing obligation if that's what the court concludes. I say you shouldn't, but if you were to conclude that. But whether we are continuing to breach on an ongoing basis is, in my submission, a different point for the reasons set out in JALA, that the breach might give rise to a state of affairs that South Bank considers to be a problem, an ongoing problem, but that's not an ongoing breach, that's the effect of a single breach. Even if the obligation was one that was continuing, as I would accept clause 9 is a right that South Bank has for longer than a day, if that was also included an obligation, we only breached that once, if there was any breach, and that was in June 08 when the lease was granted. So the key there, I think, is probably in paragraph 24 of JALA. I'm conscious of the time.
Yes. You probably pretty much covered the ground, have you?
Yes. I've made the point that the grant of lease is a one-off event. I cite as authority for that proposition Spore and Green. It may be that there's not much between us on what that's authority for. I say that's authority for the proposition that the grant of the lease is a one-off event, and one can see that in Spore and Green. The facts of that case are a little complicated. I don't propose to go through them. In very short order, what happened was that in 1846, the plaintiff acquired land from the transferee of the defendant, Mr Jameson, who'd acquired land in 1845, but still with the benefit of various covenants for title and for quiet enjoyment from the defendant. 1865, part of that land subsided by reason of mining operations that had been carried out and completed by 1845 by some third parties. That those mining operations had been carried out pursuant to a lease granted in 1844, so before the plaintiff had acquired the land. And that was a lease of the veins or seams of coal beneath the plaintiff's land, together with the right to dig for and extract the coal. And one saw yesterday that there's the passage from, well, there are two passages worth turning up. One's at Authorities, Volume 1, Tab 11. Page 142.
Sorry, did you say 142?
Yes.
Yep.
Once about halfway down, if the existence of the lease could, contrary to my opinion, already expressed, be regarded as a breach of the covenant for title by reason of it being an encumbrance which diminished the value of the property, then this breach was completed in Jameson's time, as a breach completed before the plaintiff acquired the land. And then the second passage I draw your attention to is at 143 in the judgment of Baron Bramwell. He deals with the breach covenant for title in the last paragraph. Halfway down, this is an allegation of special damage resulting from the breach, which being untruly stated, the plaintiff could not prove. The breach, however, remains and is correctly stated, but assuming the breach to be correctly stated and proved, I'm of the opinion that the statute of limitations is a bar to it, if it was completed, it ever existed at the time the deed was executed. Jameson had recovered on it or released it. No further action on it could have been maintained by him, nor consequently his assignee. It is not what is called a continuing breach, any more than not paying money is a continuing breach. Covenant remains broken, indeed broken once and for all. Finally, on this point, it's the judge's observation in judgment 385. It's called bundle 6.
385.
I'm so sorry. Judgment 385, core bundle, tab 6, page 140. It's the Bell point, effectively, that the fact that it could have been remedied doesn't mean it is a continuing breach. Respectfully agree with the learned judge there. And the second reason is that, as I've already trailed, the second reason why South Bank can't be heard to say that the failure to procure a surrender, or as it says in its skeleton, a failure to secure daily performance was a continuing breach. Well, there's no allegation of that in paragraph 15. There's no allegation of the reasons, what things we should have done and didn't. The only thing relied on is the grant of the lease. So then, finally, if I may, on ground 4, or respondents ground 4, the 4th issue, as the judge ought to have concluded that the alleged breach of clause 9 did not cause South Bank to suffer any loss in any event. The act complained of, we say, simply didn't give rise to any loss. The substance of South Bank's claim here has nothing to do with the grant of the lease. It's all to do with the underlease. And its entry into the underlease, which required it to pay rent to Lodgeshine under the underlease. When the judge made some observations about this at paragraph 386, same page of the core bundle at 140, in my submission, the judge was plainly right when he made these observations. He says 3 lines down, if the grant of the lease was a breach, it did not cause South Bank any loss. We said, since the lease did not result in South Bank losing any right to utilise for no payment, that loss, if there was one, arose pursuant to the underlease, to which South Bank consented by executing it. that argument was mentioned briefly in closings. He says, I consider that argument to be instructive and to support his conclusion in paragraph 383. Judge goes on, the grant of the lease was not of itself injurious to South Bank's interests. Conceptually, even after granted lease, hotels could have requested Lodgeshine not to complain of South Bank's continuing use or to grant South Bank a licence.
But so just pausing there, in the absence of requesting Lodgeshine not to do something, it was injurious, wasn't it?
The absence of Lodgeshine.
I mean, if your client, if Hotels was not going to request Lodgeshine to provide South Bank with free access, then the grant of the lease was injurious.
Well, not of itself, not the grant of the lease. What is complained of on my lord's example is a refusal to procure a surrender of the underlease.
Well, on the face of it, at the point you grant the lease, you put someone else in the position of deciding whether or not South Bank gets access to the annex. And unless you say you had complete control over Lodgeshine, then you had no ability to stop Lodgeshine from insisting on payment or prohibiting access or whatever. That seems pretty injurious.
My lord, that's as you say, that's the grant of the lease, but that was a grant of the lease.
Well, the judge says the grant of the lease was not itself injurious to South Bank's interests. Well, if you've put it out of your power to give the access that's on this hypothesis you were obliged to give, that seems pretty injurious.
Well, only insofar as it causes any loss. I mean, the loss that they're claiming or they're complaining about is the sum they're paying under the underlease, not a sum not another loss they've incurred by reason of the grant of the lease.
No, I mean, if Lodgeshine had simply said you can't have access at all, as you had put it in Lodgeshine's power to do, then that would have been subject of another claim for loss.
Well, if that's what had happened, that's not what happened. What happened was that South Bank consented to an underlease and assumed an obligation to pay under the underlease. I think what's said now is that, well, that was our attempt to secure alternative performance of the rights that wasn't being granted to us under Clause 9, and that's our loss.
I mean, in terms of the last bit,
Yes.
The suggestion that South Bank's position is different because it consented to the grant of the underlease. I mean, there's no suggestion of waiver of a contractual claim or whatever, is there?
In my defence, there's no suggestion of any waiver. That's right.
I mean, yeah.
What we say is that, we sort of put it slightly differently, I suppose. We say that instead of calling breach and seeking alternative performance and saying that's what they were doing, they didn't do that. They consented to an underlease instead. And insofar as they've suffered a loss or incurred liability, it was that was the cause of the loss they're now complaining about, not the grant of the lease. They didn't complain about the grant of the lease and seek alternative performance on that basis. It's slightly unreal to say that's what happened. But that's not what happened. What happened is they entered into an underlease. My lord, my lady, I don't propose it being
I think you're running out of time.
45 to trouble you further on that last point, or indeed unless there's any other matter on which I can assist, subject to turning briefly. Those are my submissions.
Thank you very much. Mr. Welling.
Thank you, my lord.
Just give me a moment to tidy up
Yes.
files.
My lord, my learned friend started with the facts, and I'm not going to say anything more about those. There is just one overarching point that I want to address, because it was suggested that I'm relying on some sort of unspoken thesis that Mr. Conway was guilty of conscious impropriety. And just so it's, I hope it was clear, but just so it's absolutely clear what I'm, the criticisms that I am making of Mr. Conway, fundamentally, as the judge found, he knew that South Bank had a legal right to the annex, and he knew that he was taking that away. Indeed, he positively intended to take it away. Now, I do not, for any purposes on this appeal, seek to go behind the finding that in doing so, he did not consciously appreciate that what he was doing was wrongful, and he was therefore not dishonest. But I do maintain, for the purposes of this appeal, and it's relevant to a number of the grounds, that that behaviour fell far below the standards required of a fiduciary, essentially for two reasons, which are not going to come as any news, I hope, to anyone. But first, even if Mr. Conway thought at some general non-legal level that there had been a mistake in the legal position, he was hopelessly conflicted in dealing with it. Because correcting the mistake, and I put mistake in inverted commas, obviously preferred his personal interests over South Bank's, whereas maintaining the legal position, even if at a high level the result of a mistake, obviously benefited South Bank. And essentially our case is that no independent director acting with single-minded loyalty to South Bank would have given up known, valuable and vested legal rights for nothing in return. And second, we say that not only was he hopelessly conflicted, but that he did not consider that he was acting in the best interests of South Bank. That is, he did not consider that giving up those rights would be most likely to promote the long-term success of South Bank. That was never part of his thinking. The highest he can put it is if you start from the point that this is all a mistake, it doesn't cause any disbenefit. But that is a completely different question. And it is certainly not a view that the long-term success of South Bank was promoted by giving up an integral part of the hotel and the hotel's business for nothing in return. So let me then turn to limitation. I'm going to address our appeal first and respond to my learned friend's submissions under three broad headings, which are purpose, what is the trust property, and what is conversion. Now, just dealing with purpose first, my invitation to your lordships and your ladyship is to conclude that my learned friend could not put forward any explanation at all for how it could be consistent with the purpose of section 21(1)(b) for Mr. Conway to be able to rely on limitation in this case. He didn't disagree with what Burnden identifies the purpose of the section to be, but he made 2 points. The first is he said, well, you need to start with the words. But it's trite, I'd suggest, that interpretation is not an exercise of reading words in the blind and only then cross-checking it against purpose. It's a unitary exercise where you read the words in their context and given the purpose of the statute. And one can see how important purpose is in construing these words from Burnden. Purpose is the only thing that their lordships referred to as driving their interpretation of section 21(1)(b) and driving it in a direction which the Court of Appeal had identified as perhaps not the most literal interpretation of those words. He also said that there are competing purposes in section 21 which need to be harmonised, and I don't disagree with that at all. Indeed, I may even agree with it. But the way you harmonise those two purposes, one being finality, the other being the Burnden purpose, if I can put it that way, is to identify what is the dividing line between when finality rules, and when fairness to the trust rules. And the dividing line is that fairness to the trust governs where the director has come off with some property which the trust had and the director should not have had. That is essentially where the dividing line is drawn. If the director is better off because of the use or possession of trust property, he does not get the benefit of the statute. And we say that once you apply that purpose, there is no difficulty identifying how Section 21(1)(b) ought to operate in this case. Second, can I just deal then with the nature of the trust property? And as I said in opening, our case is that the trust property here is South Bank's proprietary beneficial interest in the annex, which arose in equity immediately upon execution of the freehold sales contract. And I accept that is a sui generis type of equitable interest, but it is nonetheless, as the authorities identify, a genuine proprietary beneficial interest in the property. Now, just to clear one point out of the way, my learned friend made a point that we're not relying on the lease as being the proceeds of trust property for the purposes of Section 21(1)(b), and that is right. The reason being that the lease was was never in the possession of Mr. Conway, and nor was it previously received by Mr. Conway in the capacity as director of South Bank. So the proceeds limb can't apply. But that doesn't tell you anything, because our complaint is, as it was below, that what Mr. Conway has converted is the beneficial interest, the right to enjoy the annex, which we say is trust property. We don't need it to be proceeds, it is simply the trust property itself. And that falls squarely within the trust property limb of Section 21(1)(b). Now, the primary way I think my learned friend tried to get around that analysis was to say, well, actually South Bank doesn't have a beneficial interest, a proprietary interest in the land. All it has is a right to seek specific performance, and he relied on Jerome and Southern Pacific. At the danger of perhaps just going back over what had been said in opening, could I just ask you to take out Jerome, which is in, it came with the respondent's supplemental skeleton. It is in a bundle, but I don't remember what colour. Tab 4, page 26, in the very big numbers. And I really just want to emphasise paragraph 32, because this is obviously House of Lords authority, we say obviously dating back to the 1800s, but this is modern House of Lords authority, which says in terms of paragraph 32, neither the seller nor the buyer has unqualified beneficial ownership. Beneficial ownership of the land is in a sense split between the seller and buyer. ... Now that is the clearest possible authority that my learned friend cannot be right to suggest that the true position is the seller retains the entire beneficial interest and all that the buyer has is a right to seek specific performance. That is clear authority that some part of the beneficial interest passes. And of course we know that what part of the beneficial interest passes is that reflecting the entitlement under the sale contract, i.e. the right to enjoy it from the date of anticipated completion. So of course the seller can retain the benefits, can retain rent and so on up to the anticipated date of completion, but the right to enjoy matters thereafter belongs to the buyer in equity, and indeed the seller as trustee is obliged to protect that interest precisely because it is the property that is subject of the trust and the property in which the beneficial interest has already passed. The other case my learned friend relied on was the Southern Pacific case, but I don't think I need to say anything more about that. The key point is that absolutely nothing in that authority is casting doubt on the settled proposition that the buyer does obtain a proprietary beneficial interest. All that was being determined in Southern Pacific was that because of the rather peculiar nature of that defeasible submodo, as it's sometimes put, beneficial interest, the buyer cannot themselves subgrant any proprietary interest. That is all that authority stands as authority for. It certainly does not follow that that means that the buyer has no beneficial interest at all. Why is all of this important? Because we say the proper analysis is that South Bank had trust property for the purposes of section 21(1)(b) in the form of the equitable, beneficial, proprietary interest in the freehold of the annex at the point the Annex Lease Scheme was entered into. And therefore there was property, trust property, genuine class 1 trust property, which was capable of conversion. So that thirdly brings me to the question of conversion. Now, I didn't understand, my learned friend, to take issue with my submission that conversion is apt to cover any dealing with property which is inconsistent with the rights of the true owner. What I understood my learned friend to be arguing was that there could be no conversion in this case because South Bank could still get specific performance, even if it might also have to seek damages or an abatement of price because it was getting less than it was promised. We say that is a fallacy that depends on a misunderstanding of the trust property. Once it's understood that South Bank did have a proprietary interest in the land, it had a beneficial interest in the land, reflecting its right to enjoy the full benefit of that land with effect from the completion date, then we say it is self-evident that there is a conversion when, as a result of Mr. Conway's actions, South Bank loses its rights to enjoy the annex and Lodgeshine gains them, at least for the period of 999 years. Again, at real danger of going down a rabbit hole, can I just deal very briefly with section 27 of the Land Registration Act and whether granting a lease constitutes a disposition of the freehold? That's section 20, the new blue folder, I think, tab 3. And what I'm going to suggest is that my Lord Justice Newey's instinctive reaction to this section was right, and my learned friend's perhaps successful attempt to persuade your lordship otherwise was wrong. The way section 27(1) works, if you imagine a freehold out of which a lease is being granted, section 27(1) means that the disposition, which is the grant of the lease, of a registered estate. Now the registered estate there is the freehold, because you don't have a registered estate at the point the lease is granted, you are seeking to register it. So this is saying, effectively, if the grant of a lease from a freehold is required to be completed by registration, then that disposition does not operate until it is registered. And then 27(2) makes clear that in the case of a registered estate, so take a freehold, a transfer of the freehold is a disposition, but also 27(2)(b), the grant of a term of years is a disposition of the freehold. And you can see a similar point, if I can demonstrate it, in 27(3). In some ways easier to see here. 27.3 says, in the case of a registered charge, dispositions which are required to be completed by registration include the grant of a subcharge. So that is very clearly making the point that you are looking at, if I can put it, the dominant or the registered estate you're looking at is the larger estate that existed prior, and then the disposition is the grant of a subcharge. In the same way that in the case of a freehold and a lease, the registered estate is the freehold and the disposition is the grant of the leasehold. Now, it might be said that that is a rabbit hole, but it's a rabbit hole that is helpful in demonstrating what might be seen as a common sense proposition, that granting a lease is disposing of some of the rights in the freehold. And that is why it is a conversion. Then if I can turn to the respondent's notice at ground 1, part 1, if I can put it that way, and this is what really, certainly in my perception, seemed to be the focus of my learned friend's fire. This was the point, the wrong hat point, if I can put it colloquially, or I think as he put it rather more technically, his argument was that Mr Conway was not a Class 1 trustee in respect of the lease, by reference to decisions such as Gwembe Valley and First Subsea. Now, I'm going to resist the temptation to get into the very interesting debate about whether that is still a helpful distinction and whether it is in fact right following FHR to say that property over which a trust is imposed in the trustee's hands is to be treated differently to property which originally belonged to the trust.
Before you entirely disclaim that,
Yes.
can I take you out of your course? You're going to come on to what breaches there might or might not be.
Yes.
But you definitely rely on no conflict.
Yes.
Now, you were explaining before that you say that the no conflict principle entitles you to claim compensation.
Yes.
Let's leave that on one side for a moment. On the pleadings, it also entitles you perhaps to claim an account of profits.
Yes.
And I don't think you've disclaimed that claim.
I think it certainly at first instance it wasn't disclaimed, and I think I came very close to disclaiming it in my submissions. But no, it's right to say it would be a point for election upon the entry of judgment.
Well, let me just pursue it for a moment. If you've got a claim for an account of profits on a no conflict basis,
Yes.
that feels quite like the no profit claim in Gwembe, which was held to be statute barred.
I think, my lord, if I can put it this way, it's the wrong way of looking at it, because what you have to do is work out why the breach arises. So in Gwembe, there was no dealing with pre-existing trust property.
No, a profit accrues in the hands
of the
Lasco and
Lasco.
Mr. Koshy.
So there can't be said to be any dealing or conversion of pre-existing Class 1 trust property. And so the claim, the breach can only arise by virtue of an equitable disability, if I put it that way. That is not our case here. Here we say the breach arises because of a dealing with trust property, pre-existing trust property, albeit by virtue of in circumstances where there was a conflict of interest.
And I follow that because there was a dealing, you say, well, there was a breach of the duty of loyalty, if I'm going to call it that, and that's the basis for compensation claim.
Yes.
But you also, insofar as you may be alleging that you are entitled to an account of profits simply because there was a conflict, that feels more like Gwembe.
I have to put it, and I do put it, on the basis that the right to an account of profits, if that's what we were seeking, is because of a dealing with Class 1 trust property.
Yes, I see.
And so my learned friend is right to say you don't analyse the question of limitation by reference to the relief. You determine it by reference to the cause of action, the liability. And so I have to say that the liability arises because of a dealing with Class 1 trust property in circumstances where there was a breach of fiduciary duty.
So let me take you back to the point that you were not going to explore.
Yes.
You might say, well, the trend of authorities in the Supreme Court suggests that if there is a profit accruing in circumstances of conflict, there is a true trust.
Yes.
Well, if there's a true trust, it's not a claim of constructive trust in circumstances where that is merely a formula for equitable relief. It is a claim for breach of trust.
Yes.
A claim for breach of trust in relation to property of the trust.
Yes.
Now, on that thesis, this would be a claim on the account of profits, no conflict basis,
Yes.
for breach of trust in relation to property held on trust for your client.
Yes.
That sounds like class 1.
Yes, and personally, if I'm allowed to say this, I would agree with that analysis, that if the property is held on trust because the fiduciary is treated as, although they put it in their own pocket, they're not allowed to say that. They have to say they were holding it for the benefit of the trust. The refusal to hand over that property is a Class 1 breach of trust because it's property they hold qua trustee, and they ought to simply hand it back. Their failure to do so is a Class 1 breach of trust. The reason I'm not going down that road,
You say you don't need to go there.
I don't need to, and as much as I would love to do so, I don't want to end up in the Supreme Court arguing the FHR point on this case. I don't think that's going to be in the interest of any of the litigants, even if it might be in my personal interest, disavowing any conflicts.
Conflicts.
And I just don't need it. We put our case, and I'm either right about this or I'm wrong about this, on a pure Class 1 basis. And we have to do that because we need to get through the conversion to own use of property previously in the possession of the trustee point anyway. I have to put this on the basis that there was a dealing or a conversion of South Bank's property in the freehold, in the annex. And if I can't succeed on that, I fail on limitation. So anything else for me is a problem.
Yeah.
So a very concise way of putting that might be to say that if there is a claim for an account of profits, the profit is in fact the same property which
Yes.
was previously held by the company.
Yes, it would be. But I
It's
do
just a way of, it's really a way of describing a restorative remedy. In that
Yes.
case.
And that's my point about being, you can't look at the relief, not least because otherwise you wouldn't know the nature of the breach and therefore the limitation analysis until you'd entered judgment and got to the stage of electing between profits and damages. And it can't possibly be right that you can't know the limitation position until you know what relief is actually being claimed. So that's the way I put it. And I've really dealt with the point that I wanted to make about Gwembe Valley. Gwembe Valley doesn't help here because the entire point about Gwembe Valley is that the profit, well, let me put it another way, there was no dealing with any pre-existing Class 1 property. What Mr. Koshy did was essentially get two companies in which he had involvement in each to enter into a loan arrangement where, because of the mismatch in local currency and dollars and a way he had of raising local currency in a cheap way, he was able to exploit effectively an arbitrage. But he wasn't taking anything which had previously belonged to GVDC. As Lord Justice Mummery held, the only thing that was wrong with the profits was that there hadn't been disclosure to GVDC of the fact that he was going to make some money out of this. And that is a classic Class 2 situation. But it simply tells you nothing about this case, where my entire case is premised on the fact that South Bank did have a proprietary interest in the annex. And Lodgeshine ended up with the benefit of the annex thereafter. Now, I'm either right or wrong about that analysis, but that is plainly a Class 1 analysis. Same applies to first subsea, where all the discussion was, well, perhaps I'll just turn it up. It's Authorities 3, tab 42. paragraph 59. And this really encapsulates the point that I've been making, perhaps not with the greatest brevity, but paragraph 59, Lord Justice Pan says, the provisions of section 21(1)(b in respect to the property of the company have no application to cases like Gwembe, where there is no misappropriation or receipt of pre-existing company property, but only a breach of duty which gives rise to a constructive trust over the secret profit. Now, we are not suggesting that this is a case where there was only a constructive trust over the lease when it came into the hands of Lodgeshine, or the proceeds of the rent when they came into the hands of Lodgeshine. We are saying there was pre-existing company property, namely a beneficial interest in the annex, and that there was receipt of that by Lodgeshine because it got rights that were carved out of that beneficial interest. And that is the way we put our case. That is a classic Class 1 trust case, and therefore, in my submission, my learned friends' arguments on Gwembe Valley and First Subsea really missed their mark. And if I can perhaps just reiterate a point I made in opening, which was, we'll take my example of the shares held by the bank as custodian, with the company simply having a equitable interest in those shares under a bare trust. And then the director tells the bank, please transfer those shares. No one would suggest that there is a problem with that engaging section 21(1)(b and the director, it being possible to sue the director if those shares came into his hands or his company's hands, even though the actual transfer of property took place at a different level and was a transfer of property that the director could not themselves carry out. Only the bank, in my example, could transfer title to the shares. But then I ask, if you just turn up the defence, core bundle, tab 11, page 222, and this is obviously my learned friend's position as to what happened. This is in long form, paragraph 16b, Roman 6, sub 2. And it's being said, as Southbank knew full well, the underlease was entered into it as part and parcel of a transaction involving both the lump lease and underlease, and by entering the underlease, Southbank expressly or impliedly acknowledged, consented, etc., to the lease. Why is that different to my example of the director instructing the bank to transfer? If Mr. Conway, in his capacity as director of Southbank, consents to the grant of the lease, knowing that it will reduce the property rights of Southbank, why is that any different to my example of the director instructing the bank to transfer the shares? They are fundamentally, there is no real difference between those things. The director of the company is involving himself positively in an arrangement which results in a diminution of the company's property rights, even though somebody else, in fact, executes the relevant transfer. And indeed, we'd say it would be no different even if he hadn't positively consented, if he'd simply stood by knowing it was going to happen and allowed Southbank's property rights to be diminished by a transfer by Galliard Hotels. Equally, he has still converted those rights to his use by allowing the property of the trust to be diminished. That then leaves me respondents' notice ground 1 part 2, which was the question of own use, what's meant by own use. And my learned friend took this briefly. I think he positively accepted that conversion to own use could occur if the director has sufficient control, his words, sufficient control over the recipient company. The argument seemed to be one on the facts. What he said, as I understood it, was the judge said that he'd seen no evidence that Mr Conway controlled the 52% of the shares in Galliard Hotels, and therefore it could be inferred that the judge was not satisfied that Mr Conway was able to control Lodgeshine. So this wasn't a case where there was a finding of sufficient control of Lodgeshine. Now that's not a fair reading, I'd suggest, of the judgment, but it's also fundamentally an argument that's not open to the respondent for two reasons. The first, as my Lord Justice Miles explored, I think slightly later in the discussion with my learned friend, that doesn't fit with Mr Conway's own evidence that he had control of Galliard Homes. Now, if he has control of Galliard Homes, and Galliard Homes holds 100% of the shares in Lodgeshine, he has control of Lodgeshine. And indeed, perhaps even more fundamentally, it's a point not open to my learned friend because it's inconsistent with an admitted position in the pleadings, which is Core Bundle tab 11, page 231. Uh, 231.
And that's paragraph 17. 17F, I think.
I'm going to agree.
I don't know,
I think it's still in
It is 17.
17. 17F Roman 1. So there's no need for the judge to make a finding because it is admitted that at the relevant time, Lodgeshine and South Bank were wholly owned subsidiaries of Galliard Homes, which Mr Conway controlled. Now, why he admitted that and the basis on which he was able to exercise control through a 48% shareholding is not a matter that ever needed to be investigated. It was admitted. And so we say this is a case where if the test is sufficient control of the recipient company, it is simply an admitted fact that Mr Conway had complete control of the recipient company. And again, I do just ask your lordships and your ladyship to step back and think about the purpose of section 21(1)(b). Is it really credible to say that section 21(1)(b) is not engaged where the property goes into a company of which control is admitted, the director, the wrongdoer, the defendant is the sole director, and indeed that person stands to obtain 48% of the economic benefit? I mean, that is absolute classic situation, you would think, where section 21(1)(b) should be engaged. That then leads me to respondents' notice ground 1 capital A, and I feel that we might perhaps, between the pleadings and the ground numbering, have come up with something more accessible. But this is the breach ratification and excusal issues. I'm not going to retreat from my primary position that it is best for you to remit this. I do say, having listened to my learned friend, it does not seem to involve the detailed trawl of the facts that I'd perhaps expected it would, and you may feel that there are some or all of the areas on which you are able to reach a conclusion, that there is only one sensible answer on the facts found by the judge. And it may be that varies between the issues. Ratification is an obvious candidate, I'd thought, where there is only one possible answer on the facts. But let me just run through what I say. In terms of breach, on the no conflict rule, my learned friend's answer to that appeared to be 2 points. The first was that there was a pleading point, that we had not pleaded causation. Now, can I suggest, with the greatest of respect, that that sort of pleading point is not likely to be of great assistance to your lordships and your ladyship. We specifically claimed the diminution in value of the property and the sums we'd had to pay under the underlease as damages. And I don't think anyone who has read the documents in the case could be under any illusion that our case throughout was that no honest, reasonable and independent director of South Bank would have given up its rights for nothing. Now, whether that is right or not will be a question to be determined on the quantum phase. There obviously is a causation question that will have to be determined as to what, if we are right about a breach of duty due to conflict, what the a truly independent director would have done. And Gwembe Valley makes clear it is not sufficient for us simply to say there was an act in breach of the conflict rule and therefore we treat that thing as not having happened. The burden would be on us to demonstrate that an independent director would have done something different. But the idea that we haven't pleaded that and therefore you can simply pretend we haven't made a breach of duty claim is, I suggest, unreal. The other argument was one of waiver. Now, I'm not sure what is meant by waiver there or by whom. The only way that conflict could be waived, given that Mr. Conway is acting as director of both the companies and can't waive his own conflict, would be a ratification by Galliard Homes. And that's, of course, a separate issue. I think my learned friend's final point on this was that he said, well, you have to come back to the underlease, and there couldn't have been any conflict in granting the underlease. Ultimately, we say that just starts from the wrong position. If we're right about breach, it's not the grant of the underlease that is the breach, it is the entire Annex Lease Scheme that is the breach, including the lease, because they form part of a single package to rentalise the annex. And once that...
Do you say that that was actually part, I think you showed us a bit of the defence, where that was actually part of the defendant's case.
It is.
That they were part and parcel of
Yes.
a single
Yes.
transaction.
Yes. And it's part of the defence case. And also, if you look at the way it's pleaded in the re-amended particulars of claim, in that first paragraph, I think it's 33.1, whatever the point 1 is, we plead that he caused or permitted the entry of the lease and underlease. So it's never been our case that it's just the underlease. That's an attempt to deploy the hats argument against us, if I can put it that way. We say he's simultaneously wearing the hats of all the companies in bringing about a single composite scheme. And the conflict is therefore in bringing about the scheme, including, as he himself contends, consenting to the grant of the lease. Or acknowledging the grant of the lease, consenting or acknowledging. Duty to act in good faith. Now, my learned friend took you, and it's probably just worth having it out, paragraph 175V, Roman 5, of the judgment. That's Core Bundle 6, tab 96. And as I understood the argument, Malone was saying, well, this demonstrates that Mr. Conway did consider what was in the best interests of South Bank, and that defeats our claim. Now, the problem with that is that even taking this paragraph at its highest, what it finds is that there's no disbenefit if you take as your starting position that South Bank's legal rights were the product of some high-level mistake. But the problem with that is it does not engage whatsoever with the thought process that was required of Mr. Conway by Section 172 of the Companies Act. And just to pause there, Section 172 was in force at the relevant time. Other parts weren't. So the provisions relating to conflicts were not dealt with under the statutory regime. They were dealt with under the prior equitable regime. The question, as the court well knows, under Section 172, Mr. Conway has to think about what is most likely to promote the success of the company for the benefit of its members as a whole, having regard in particular, it's one of the listed items, to the likely consequences of the decision in the long term. So it's not simply thinking about, does it benefit the current members? It is, does it benefit the company and its members as a whole over the long term? And keep in mind that in this case, the long-term consequences undoubtedly include the impact on the holders of room leases, not only because, of course, the company knows that that's what it's been set up to do, to own and operate the hotel for the benefit of the room lease holders, but also because the articles of South Bank provide for the allotment of shares to room lease holders as soon as South Bank has received the freehold. So it is not, they're not merely theoretical future shareholders. The company is obliged to allot the leaseholders with a share.
So that's the legal mechanism by which they were going to get the shares.
It was. It comes in two forms. The room contract, so not the room leases, the very original investment contracts contain a promise by Galliard Homes to either transfer to them or allot to them shares, and then the articles themselves have an express provision that requires the allotment of shares to the leaseholders.
And I haven't focused on that, but that's somewhere in the judgment, is it?
I'm not sure it is, but it is in the articles. Obviously, if you want a copy of them.
I think we would like a copy because that's not in the supplemental bundle, is it?
It's not.
So it's not in the judgment and it's not in the supplemental bundle. It would be helpful to see the
I will
articles.
make sure you receive that. I don't think what is not controversial, I think, and is recorded in the judgment, that the structure of the investment was always set up so that the leaseholders had a right to get a share in the South Bank. But yes, we will do that, and I will just tell you so when you see it, you
So
can.
it's
Seems
being
that
done
you
this
are doing
moment.
that.
It's paragraph or article 8 when we get copies to you. What it says is, as soon as is reasonably practicable after the relevant date, the company shall allot and issue one share at par to each person who is a unit owner as at the date of such allotment, and the relevant date is the date on which the freehold interest in the property is transferred to the company. So the question, and just when you see these articles, so it doesn't come as any concern, they refer to Bridge Guide Limited. That was the name of South Bank until January 2005, so it is the right company. So the question Mr. Conway had to ask himself is, what is going to be best for South Bank and its members in the long term? That's the question he had to ask, not, is this something which causes no disbenefit if I start from the position that the legal rights which South Bank has are mistaken? And we say, therefore, Section 175F is absolutely no answer to our claim for breach of the duty of good faith. It simply demonstrates that he didn't ask the relevant question because he started from entirely the wrong starting point. We say this, therefore, is a case where the objective analysis has to be applied, and we do say if the court wants to do so, it's well placed to answer the question, could a reasonable and honest independent director have concluded that the right course was simply to give up valuable vested rights for nothing? Because there's only one sensible answer to that, and the answer is no. And one can test it by saying, well, if I were the director, would I have contemplated giving up all of those rights for absolutely nothing? And if your answer is obviously not, there's plainly a breach. But even if it were a subjective question, on the findings in the judgment, Mr Conway plainly didn't believe that the Annex Lease Scheme was in the best interests of Southbank, the best long-term interests of Southbank. He knew on the judge's findings that he was giving up valuable vested rights and simply think, well, it's no disbenefit because I never intended you to have them. It is no answer to the point at all. It just doesn't engage with Southbank's best interests.
I'm sorry to ask this at this stage, but because of the point about
Ominous,
section 172,
Yes.
does the subjective objective test set out in Charterbridge survive the passing of section 172? That was a test which was about the acting in good faith, bona fide in the interests of the company.
Yes.
Is there authority that that same distinction has been applied since section 172 came into force?
What is worth, I'm sure there are cases, certainly at first instance level, probably the Court of Appeal, where Charterbridge has been used post Companies
Yes.
Act 2006.
Well, re-HLC, which we've got in Authorities Bundle 2, tab 35, was a case where the breaches, I'm not sure, you're welcome to send it up to Authorities 2, tab 35. It's first instance.
But it in itself, I know, has been cited elsewhere subsequently.
One of those cases that has been, that was a case, as you see at page 753, and you'll see at paragraph 87, there were breaches before and after the coming into force of the Companies Act 2006. So 87 Roman 1A is the prior duty to act bona fide best interests. That's paragraph 87 Roman 2A is the duty under section 172 to like effect. And you'll see then at paragraph 88, it's said by the deputy judge that section 172 effectively codifies the good faith and the promote the success. Sorry, the section 172 promote the success effectively codifies the pre-existing common law position. And then certainly at paragraph 92, the judge deals with this point about subjectivity without suggesting that there's any distinction between the pre or post Companies Act 2006 position. So certainly the judge in this case was approaching it on the basis that although the language was different, the same approach applied. And in my submission that must be right, because if you have something that requires you to ask under the language of section 172, what did the director believe in good faith was in the best interest of the company? If the director in fact doesn't have any belief because he never thought about it, you've got to have some test to apply. And the objective one, I would suggest, is the only sensible one that can be applied. Ratification, not really much to say about this. My learned friend took you to the Siban case. Now, I accept that shows in fairly extraordinary circumstances, a person with ostensible authority to represent the sole shareholder can ratify. I mean, that's classic ostensible authority. You can do something on behalf of your principal without your principal knowing. But there's no basis, I would suggest, in the findings to conclude that Mr. Conway had been given that sort of authority simply to entirely bypass the board without any reference to them at all, even if they were accustomed to follow his advice. That's a very different thing. But leave that to one side. It simply doesn't engage with what is the most fundamental problem my learned friend has, which is that you still need an objective, overt act of ratification by the shareholder, brackets, or the shareholder's representative. But where is the objective overt act of Mr. Conway, even if he were in that position, to demonstrate that he was ratifying on behalf of Galliard Homes? He simply does the deal on behalf of Lodgeshine Hotels and South Bank. There's no evidence, no objective or overt act indicating that he's doing anything qua representative of Galliard Homes. Finally, excusable. My learned friend, I think, suggested to you I couldn't say that Mr. Conway had behaved unreasonably because the judge found that he'd acted reasonably. I would just, and I think my Lord Justice Miles asked some questions about where those findings were. What I would say is that the judge did not make a finding that Mr. Conway had acted reasonably. He made specific findings that particular beliefs were honest and reasonable. But he did not make a finding stepping back as to whether his conduct as a whole was reasonable. And in my submission, it was fundamentally unreasonable for a director of a company that effectively is there for the interests of investors to involve himself in taking this sort of decision where there is an obvious conflict of interest, and without ever stepping back and asking himself, is this in the best interests of South Bank and the investors? Not, can I say that it doesn't cause any disadvantage because of a mistake, but actually, is it the best thing for them? Is this what they would agree to if they were running the company? That is a serious departure from the standards, the high standards required of a fiduciary, especially a fiduciary who is effectively taking investors' money. And that was not reasonable behaviour. But even more fundamentally, we say that there is no case for excusal here where Mr. Conway has come off with the benefit and would continue to come off with the benefit of his breach. And the only answer given to that was a pleading point, which is we didn't plead that. And it's true, there is no pleading in our answer to section 1157 that Mr. Conway has come away with a benefit. That said, section 1157 expressly requires the court to have regard to all the circumstances of the case. And clearly an important circumstance of this case is the fact that Mr. Conway has benefited and will continue to benefit at the expense of the investors. There is absolutely no unfairness in the court having regard to that circumstance. It can't be said to be something that because it wasn't pleaded, it wasn't investigated as a matter of fact at trial. We all know what the corporate structure was and who was going to benefit, and the judge made positive findings about the fact that it transferred value into Lodgeshine and therefore benefited Mr. Conway personally. And so the pleading point is no answer at all to say the court needs to close its eyes to the realities of this case. And the reason I suggest that the only point my learned friend could come up with was a pleading point is because it is blindingly obvious that you're not going to get excusal to allow you to continue to reap millions of pounds from your breach. That takes me then to ground 3, which is the validity issue. Now, it's not really, I'd suggest, a matter for your lordships and your ladyship, but just so there is no risk of it being said that I've taken anyone by surprise, my learned friend suggested that we were being rather short-sighted in arguing that the underlease was invalid because it was going to be commercially detrimental to us. Can I just explain why we say that's wrong? The position is this. Our position, if the underlease is held to be invalid, and as I say, I'm not asking you to decide this, will be as follows. Once the underlease is removed, and assuming it doesn't take effect in equity, then obviously it doesn't give rise to any legal or equitable estate. So we can leave, in terms of the proprietary consequences, we can leave the underlease to one side. Lodgeshine's lease is expressly subject to what are called title matters. and title matters are effectively those matters on the register affecting the freehold title. Now, matters on the freehold title include the room leases. They are on the charges register. And as you know, the room leases contain the grant of a right to use the annex. So our position will be that once the underlease has gone, South Bank is entitled to make use of the annex simply by virtue of the grant in the room leases, and that those the lease takes effect subject to those rights, and therefore Lodgeshine will not be able to prevent us doing so. And that is why we say we are not imperiled by the loss of the underlease. Conversely, it will have an impact on the ability to recover rent under the underlease if that is not a validly executed deed. So that is why the position matters, and I therefore, just to be absolutely clear, I think my Lord Justice Miles asked my learned junior something about do the room leases have a continuing impact? The answer to that is they may very well do if we are right about ground 3, because we will say they're a continuing title matter affecting the freehold, affecting the lease. Ultimately, on the substance of the point, which is this question about section 44.5 operating in favour of the purchaser, my fundamental submission to you is that my learned friend could not offer a coherent interpretation of section 44.5 which made any sense of the words in favour of the purchaser. And that's not a criticism of him, simply reflects the reality that his case rides roughshod over the words in favour of the purchaser. What he really seemed to be saying was, well, actually it operates in favour, it applies to both the seller and the purchaser, but that just ignores the opening words. And perhaps most tellingly, when my Lady Justice Asplin suggested to him that on his construction, the effect of section 44.5 would be to lock in the purchaser, he said, yes, it does lock in the purchaser by not allowing it to take technical points. But that is obviously wrong. It means something that is meant to operate in favour of the purchaser, in fact, operates against them. And it would produce the extremely odd result that if the seller had been acting in bad faith, so the seller is entering into the transaction in bad faith, it could hold a good faith purchaser to the contract, even though the good faith purchaser didn't want to be bound. Because you say, well, that's operating in favour of the purchaser, and the purchaser was in good faith, so no problem that I, the seller, was in bad faith. On any view, that is not serving the purpose of the statute, and it is certainly not applying the deeming provision in favour of the purchaser. So we say we are plainly right about on ground 3. Finally, from me, ground 4, and then obviously the linked respondents notice points. Ground 4 is a question of good faith. My learned friend referred you to 2 cases. The first was Lovett, and I don't need to turn it up. That's Authorities Bundle 2, tab 31. Obviously, the facts were somewhat similar because you had a seller who was there was a practice of someone else signing documents in a different person's name. But the case obviously tells you absolutely nothing because the purchaser, the bank, had no idea that that was happening. So it simply didn't engage with the question of what is good faith. What an authority I accept is on more on point is Smith and Morrison. So that's in the blue file, tab 5. And I think I have to commend the diligence of my learned friends in finding this. As we've done a fairly detailed trawl and have not come across this authority. If it's any excuse, perhaps it's because it deals with the land registration official searches rules, which is not perhaps, we looked at various Land Registration Act and Law of Property Act provisions, but this one had passed us by. And the question in the case, it's tab 5 of the blue file. was essentially, was the purchaser who obtained the official search in that case acting in good faith? And could they therefore rely on the priority accorded by the search, where they had been told in terms that someone else was asserting that the property had already been sold to them, but they were convinced by the seller that that was not in fact the case, and they genuinely believed that the claim was at best a weak one. And the conclusion of Mr Justice Plowman, and you see this on page 676, letters E to G, I accept Mr Justice Plowman regarded it as sufficient to amount to good faith in that context, that there was not dishonesty. He says, about halfway down, so far as the law is concerned, in my judgment, if a purchaser acts honestly, he is acting in good faith within the meaning of Rule 2 of the Rules of 1969, and I so hold.
Sorry, I wasn't keeping up.
Sorry, on page 676,
Yes, I see.
just above letter F,
Yep,
so far
I
as the
see.
law is concerned.
Yes.
And obviously, if that is right, in our context, it is fatal to my position. My submission to you is that it is too narrow. It would have been too narrow even in that context. But ultimately, I don't need to go that far, because my submission to you is that the words good faith have to be construed in the context they appear, and having regard to the purpose of the particular statute. And if one goes back to page 670, at the very, very bottom of the page, there was a quote that my learned friend relied upon from Lord Denning, talking about the Leasehold Reform Act. And at the very bottom of the page, Lord Denning says, how then are we to decide whether the tenant's claim to buy the freehold is made in good faith or not? Words in good faith are often used in statutes but rarely defined. Good instances, the Larceny Act. Other instances come readily to mind. Limitation Act speaks of fraud. All such cases, when a word or phrase goes undefined, the judges have to work out for themselves the meaning of it, doing the best they can to interpret the will of the legislature in regard to it. And that, I suggest, is right. It's got to be looked at case by case. What is good faith in the context of applying for a leasehold may well be different to a claim of right under the Larceny Act, now the Theft Act, may be different to what is meant in a technical conveyancing or execution statute. And one can see that obviously different views have been taken in different contexts. Lower down that page, you have a reference just below F to the case of Leneve and Leneve. And if you go over to page 672, just at letter B, in Leneve and Leneve, it was said that the ground of it is plainly this, that the taking of a legal estate after notice of a prior right makes a person mala fide purchaser. So there are certainly circumstances in which notice of the problem, if I can put it that way, is sufficient to deprive a person of good faith. And so the real question is, in the context of this particular statute, what does good faith mean? Does it simply mean that the transaction as a whole was honest? We submit not. We submit that where what you have is a deeming provision which enables a person to treat a document that purports to have been executed in the manner provided by a statute to have been so executed, the obvious meaning of good faith in that context requires that the person does not know that it in fact has not been executed as it purports to have been executed. Why, I ask rhetorically, would Parliament have intended to protect a person or give them the protection of deemed execution where they know the true facts? Estoppel, that's respondents notice ground 3, part 1. Estoppel, really only 2 short points I need to make. At first, there is nothing in the cases we submit that shows that the estoppel against the landlord goes beyond matters relating to title. I'm not going to take your lordships and your ladyships through the cases, but FNB, for example, which my learned friend relied upon, that was a case where a person was denying the validity of a legal charge because they were not yet the registered owner of the land when they granted the charge. All of those are title matters. And that, we suggest, makes sense. That's why you need a technical doctrine of estoppel, and there's no reason why it needs to apply to execution. And indeed, it wouldn't be workable if it did, because you end up in the circular question of, well, how do you stop someone from denying execution, where the very issue is whether they've executed it. Second, and perhaps more and equally fundamentally, we submit that it would entirely cut across section 52 of the Law of Property Act 1925 to allow the estoppel to work in this way. Section 52 of the Law of Property Act, as I'm sure the court knows, is the one which treats as void any conveyance which is intended to create a legal estate unless it's been made by deed. Now, that statute would simply be written out of existence if a person who had granted a lease or a charge by simple contract was stopped from denying that their simple contract was effective to grant an estate in law. And it can't be right that an estoppel simply entirely denudes a statute of its aim and purpose. Respondents notice ground 3 sub 2, part 2, equitable lease. We say that there would be no equitable leases because they would not be specifically enforceable because of Mr. Conway's unclean hands. We also make the point about breach of trust. I accept there is force in my learned friend's argument that Snell may put the point too high in suggesting that any breach of trust, if a contract's entered into in any breach of trust, it will automatically be incapable of specific performance. One can see the difficulties with that. It could very unfairly prejudice a person acting in entirely good faith who had no notice whatsoever of the breach of trust. And that's why I said in opening, I suspect in reality, those old cases are now better seen as examples of unclean hands, that if this is the sort of case where the breach of trust deprives the party of clean hands, then equity is not going to come to their assistance to help them carry out a breach of trust. But so I really focus on unclean hands, and the answer given to me or given in response to this was really a pleading point. And can I just take up the pleading at Core Bundle tab 12, page 306. And it's paragraph 21L. And the point really being made, we can focus on the cross-reference to paragraphs 39 and 41, is that those paragraphs plead dishonesty or reckless indifference. The judge found there wasn't dishonesty, and therefore this entire paragraph falls away because it entirely depends on an allegation of dishonesty. Now, I have to say, it is never a good sign when one has to rely on a pleading point to prevent a party relying on matters which were absolutely fairly and squarely in play at trial, namely whether Mr. Conway brought about the Annex Lease Scheme in breach of fiduciary duty. My learned friend could not credibly say he has been prejudiced in any way in dealing with the question of whether Mr Conway breached his fiduciary duties. And so we say there is absolutely no unfairness in allowing us to say that the legal consequences of that breach, if it's found to be proven, would also be a lack of clean hands. That is simply a consequence from facts which were fairly and squarely in play at trial. But in any event, I'd suggest that reading of paragraph 21L is not a fair one, not least because if you look at the final sentence, further or in the alternative, and you will just see if you read the word before further, there's a plea of dishonesty. It said further or in the alternative, and for the same reasons, the defendants are debarred from obtaining the benefit of an equitable lease by reason of their inequitable behaviour and or unclean hands. So plainly, the pleader here is saying, well, even if we don't make out dishonesty, in the alternative, but for the same reasons, the defendants are debarred from obtaining the benefit of an equitable lease by reason of their inequitable behaviour. And ultimately, when one looks back to paragraphs 39 and 41, the matters complained about there are really general complaints about the nature of the Annex Lease Scheme. And if one goes back, for example, to page 200, at the top of the page, letter K, this is part of paragraph 39. One of the matters being complained about is that Mr Conway's own evidence was that he understood that the annex would be transferred to South Bank, and he was therefore consciously aware at the time, by entering into the Annex Lease Scheme, he would be depriving South Bank of an asset which was due to be transferred to it. So that's precisely the sort of matter we rely on as being unclean hands. So it's not a good pleading point, it is an entirely technical and arid pleading point. And indeed, although you don't have it in the bundles, in our written closings for trial, the point was made as to why there were unclean hands. I'll just read it. The lease formed part of the Annex Lease Scheme, which was itself a breach of Mr Conway's duties of a director, a breach of trust, and a breach of various other obligations identified above. So we were always putting this on the basis that a reason for unclean hands was a breach of the director's duties.
Could I go back to something I asked you, whenever it was, when you were opening? This is about claims between the companies, this idea of equitable leases. So it's whether there would be specific performance between the companies. And at that time, they were all under the control of the same group. And I know I talked about a thought experiment, but what is how does the possibility that Mr Conway was in breach of his fiduciary duties to the company feed into the question of whether the court would grant specific performance of these contracts?
So I'm not aware of any authority that's ever looked at this question. And do you ask it by reference to who was in control of the companies and whether the points would be raised? The way I would suggest it has to work is because we are dealing with whether an estate in land comes up, it can't depend on the happenstance of is the director in position or not in position. It has to be a question of if the court were appraised of all the relevant factors by an independent director, would it specifically enforce the contract? And if you do the thought experiment on the basis that there were, Mr Conway was out and entirely independent directors were in each of the companies, and each of them put the best case possible forward to the court as to whether or not this contract should be specifically enforced. If South Bank turned up and said, this contract should not be specifically enforced because it was only entered into as a result of breach of fiduciary duties, of which all the companies had notice because they were under common control, the court would conclude that the contract is not specifically enforceable and therefore can't, at that time, have given rise to an estate in land. Otherwise, you have the very difficult position that you simply can't know on any given day whether there is a proprietary right, because it depends on entirely subjective questions of litigation strategy. but I accept that is a submission. It's not something for which I can provide authority. But the authorities do talk about being capable of specific performance, and I think one has to do the thought experiment on the premise that capable must mean on the basis of a fully informed court, because it would always be capable if a party chose to consent to it or So pleading point we say is a bad one. If Mr Conway was in breach of fiduciary duty, unclean hands, equity would not enforce the lease and underlease so as to give effect to his wrongful scheme. Very final point, rectification. As regards the underlease, I didn't understand my learned friend to take issue with my argument that because South Bank is the registered proprietor, it can simply consent, and that is sufficient for the purposes of the Land Registration Act, because it's not being done. As to the lease, my learned friend's submissions were on what is meant by the words proper care, and he suggested that the word proper suggests there needs to be a legal duty, and it may really be focused on people like conveyancers. We say there's no magic in the words proper care. On their natural meaning, they simply identify the care that is reasonably to be expected from a person embarking on transactions of this sort, which by their nature are important ones with significant consequences for the public, because they go onto a public register. The judge finds, and I'll just show you this before I sit down, core bundle, tab 6, page 142. Paragraph 395, judge finds that at the time he asked Ms Akers to sign the lease and underlease, Mr Conway realised that the documents would have to be sent to HM Land Registry. He accepted that he realised that anyone at the Land Registry who saw them would think that S. Conway had signed the document himself, so he knew they would be misleading documents. We suggest that for a director to prepare a deed for registration in that way, and to cause or allow it to be sent to the land register without requiring the two true positions to be revealed, is quintessentially a lack of proper care. It is knowingly risking the land registry being misled, and that is not the proper care required in and about the registration of transactions. And so for those reasons, rectification should be granted by removing the lease from the freehold title and by closing the lease title itself. I'm afraid I have run over, and I imagine my learned friend would like a couple of minutes just to deal with ground 2. But you may tell me I have used this time. And
I think you can have a couple of minutes, because with a bit of luck, Mr Trumpeter is only replying on respondents' notice points, and so that should be a little bit shorter. But Mr Burkadiri, only a couple of moments.
I'm grateful, my lord and my lady. 3 points in reply. First, pleading points. We did, as my lady, Justice Asplin observed, clearly plead continuing obligation. We also pleaded that there was an implicit right to use the annex without further consideration or further agreement. So if my learned friend's concern is that we needed to plead an implied term, there it is. But in my primary submission, we don't need to go there. My learned friend also criticised the pleadings on the basis that we didn't set out further acts which constitute a breach. In my submission, there is no need to plead further acts, as my learned friend suggested. All that's required to constitute a complete cause of action is the fact that the promisor has not satisfied their contractual obligations. Here, the contractual obligation was to give us the right to use the annex. And in a contract, you can promise to achieve an outcome, and if the outcome is not achieved, then you're in breach, whatever the cause, and whether or not the cause was due to your acts. And in my submission, that really goes to my Lord Justice Miles's observation which was whether or not continuing obligation and continuing breach were really different points. And we say very often they won't be in the contractual context. Second point in reply, just on the Jalla case, my own friend took you to paragraph 31, where Lord Burrows said that a continuing nuisance is in principle no different from any other continuing tort or civil wrong. In my submission, that passage properly read isn't saying, just like every other civil wrong, every other civil wrong needs a repeated act. All it's saying is that you need to identify the wrong you are concerned with, and if that wrong continues, then there is a continuing breach. So in the case of false imprisonment, which was identified in paragraph 31, the wrong was the act of imprisoning. In Jalla, the wrong was the act of letting oil leak from your pipeline. Here, the wrong is not providing the right to utilise the annex, and that continues day after day. The second point that arose from Jalla was this, the Delamere Mansions case, the tree. And as I say, my principal submission is don't rely on Jalla, you'll be led astray. But if you're tempted, we would submit that the tree is just like the lease. The key point is that there is an ongoing state of affairs. So in the case of Delamere Mansions, there was a tree dehydrating the soil, but the existence of the tree and what it was doing was not due to the repeated activity of the council. Similarly here, there is an ongoing state of affairs. The lease exists, and day after day, it makes it illegal for South Bank to use the annex. That's an ongoing state of affairs, even without repeated conduct. And my third and final point in reply is on loss. I heard no answer to the proposition that absent the underlease, South Bank may well have been liable for mean profits. And in my submission, that demonstrates clearly that not providing the right to utilise the annex has caused loss. So unless I can assist the court further.
No, thank you very much. Mr. Trumpeter.
My lords, my lady, can I deal first with my ground 1A, which is the class 1, class 2 point? Just as an initial observation, in the Gwenby case, of course, Mr. Koshy came off with something that the trust should have had, i.e. the unauthorised profits made by the associated company NASCO. But he was still nonetheless a class 2 trustee vis-a-vis those profits. And once one appreciates that, it becomes apparent straight away that my learned friend's plea to purpose doesn't quite work. Because when he was making submissions about harmonising the purposes in section 21(1)(b), he said fairness to the trust governs the situation where a director comes off with something the trust should not have had. And when you're on that side of the line, I think he submitted, you're within section 21(1)(b) territory. But that is far too simplistic an approach, as illustrated by the Gwenby case itself. Now, Gwenby is, of course, binding on this court, unless the court considers it was decided per incuriam. But it's not been suggested to your lordships and your ladyship that the decision is wrong, and my learned friend is not pursuing any other argument based on the FHR case or anything like that. So for the purposes of this appeal, I think we have to proceed on the basis that Gwenby was correctly decided and is indeed has to be followed. Now, in that context, I think it is absolutely critical to remember how the case is put on appeal and how it fits into section 21(1)(b). And I began my submissions on this particular issue by reference to the wording of the second sentence of ground 1 and trying to squeeze that into the parameters of section 21(1)(b). And so the position is we have a director of a company, Mr. Conway, director of South Bank, who as such in legal fiction takes custodianship of South Bank's assets. And there was obviously a debate which was the subject of South Bank's ground 1 as to the precise nature of those assets that Mr. Conway assumed responsibility for. Leave that to one side, I'm not making submissions about that. The supposed conversion of those assets involves the grant of the lease. And so the question then becomes, viewed through the prism of Grenby, whether that conversion was done by Mr. Conway in his capacity as the person with responsibility for the relevant property, i.e. either the right to specific performance or the beneficial interest in the freehold or something else. And in my submission, the answer to that is no. And we can see that from the Grenby case itself. If I could just briefly turn you back to Grenby, please, at Authorities Bundle, page 585, and paragraph 102. And my lords and my ladies.
So can you just remind us where it is?
Yes, of course. It is, so I'm working electronically, tab 29, which I believe is in tab volume 2. I'm so sorry. Thank you. And it's page 585. And one may remember Lord Justice Chadwick's analysis of the earlier Privy Council case, the Taylor and Davies case, where the inspector was under a fiduciary duty in respect of certain assignments. And as one can see from the indented quote, he didn't have the power at the relevant time to dispose of the company's property, and therefore his liability in respect of the disposal becomes a Class 2 liability. And it is exactly the same here, because at the time of the lease, Mr. Conway, with his South Bank hat on, had no power to dispose of the property in the way that it was done, i.e. by the grant of a lease. He simply had no power as a matter of law. And therefore his liability in respect of the lease arises independently of his custodianship of South Bank's property. That is the critical point. And once the court, with obviously great, tremendous respect, once the court appreciates that point, you are driven to the only conclusion that as regards the lease, Mr. Conway's liability is and can only be a Class 2 liability. So that's, I think, all I want to say on that. Can I move on then to my ground 1 big A and the question of breach? My learned friend made some submissions about a pleading point, and he said, well, the pleading point was not likely to be of great assistance. But I think tacitly my learned friend seemed to accept that causation wasn't pleaded. He submitted that we specifically claim the diminution in the value of the property and sums payable as damages, and as he put it, no one could be in any doubt about what they were looking to recover. But as my learned friend also submitted in the next breath, is that it's not sufficient to say there was a breach. The burden is on the party alleging a breach to show that a director would have done something different. And what we don't have pleaded is any kind of counterfactual case on causation. So what do they say would have happened in the counterfactual world? And that's not just an arid point, because there may be points that we could have said in response to that, bearing in mind what I called the continuum from 2005 to 2008, where we might take a different view as to how a reasonably minded director might have conducted himself or herself in the circumstances. And so what I was quite careful to do in my submissions yesterday was to avoid having to get into the weeds of the facts in this case, so as to allow, in light of the findings that the judge has already made and the pleading, the court simply to say, well, this point was never pleaded, and therefore you can't get a second bite of the cherry. So that's the question of breach. Briefly, on the question of waiver of conflict, so that the conflict is between the interests of South Bank and the interests of Lodgeshine vis-a-vis the Underlease. and as between Galliard Hotels and Lodgeshine vis-à-vis the lease. And so when I was talking about a waiver of conflict, I was talking about a waiver between those parties. So in the same way, like in the Mothew case, that of course you'll know very well, a solicitor owes duties the solicitor can't be conflicted, but the solicitors in Mothew act for the mortgage company and of course the borrower at the same time. But that's because of the mortgage company standard terms and conditions. And so the borrower necessarily waives any conflict that might otherwise arise. And it's essentially the same point here. Dealing next with the duty of good faith, my learned friend made some submissions about section 172 and said that it behoved Mr. Conway effectively to think about the long-term consequences on the impact of the holders of the room leases. Not that, as it so happens, on the impact of the members of South Bank. Obviously, the investors have two capacities. They end up becoming members of South Bank, and so they are shareholders, but they also acquire room leases, and in that capacity, they become tenants. It's in this context that perhaps it's worth
I thought you said both, actually, but I may have misrecorded that. I thought you said that you had to take into account the...
He did say because the Articles of South Bank provide for the allotment of
So
shares.
it affects the room leaseholders, and then went on to say, and there's the allotment of shares to them as members.
Yes, that's exactly my note. He said, but also because the Articles of South Bank provide for the allotment of shares to room leaseholders. Can I, one thing that's perhaps worth appreciating in this context, and I don't think perhaps and it may be my fault, it's been brought out at all. South Bank's role is really no more than there to distribute income. It's not a profit-making company. And you can see that from the room lease itself, which is in the supplementary bundle behind tab 2. And if I could just take your lordships and your ladyship just to a handful of the provisions, you'll see at page 12 certain definitions. One of which is the definition of agency payment. And you'll see in the parentheses, that is essentially monies that the tenant is entitled to when his room is occupied by guests. So that's the main return on the investment. There's also a definition of business costs, which is essentially amounts payable to the company in complying with certain obligations, a bit like a landlord who provides obligations in maintaining a block and that kind of stuff. And then also the cost of carrying out the business in Roman 2. So again, bear in mind that when Galliard puts this scheme together, Galliard is a house builder. That's what it knows. That's what it does. And because it couldn't get planning permission for a residential block, it comes up with this brilliant idea of effectively a sort of an analogue with hotel rooms. But otherwise, it kind of treats it as it would do just any other residential apartment block. And what happens is in clause 8, you can see in clause 8a, the tenant appoints the company effectively to get guests to occupy the room. And then in 8e, the company is entitled but not obliged to appoint a hotel operator. And indeed, that's what, of course, happens. And then if we jump to page 36, you can see in paragraph 1 of the 6th schedule that the company holds the agency payments, so the money it gets from paying guests, on trust for the investor. And then when one jumps to the 8th schedule on page 43, the company in paragraph 1 of the 8th schedule deducts from the income, which is basically the room income, a percentage of business costs, a bit like a service charge, and then distributes the balance to the investor. So South Bank itself was never designed to make any money. Its role is merely there to hold room payments, provide certain services and effectively to appoint a hotel operator. And so when one's considering, as it were, disbenefit to the company, if one wants to truly consider it purpose, one would consider that purpose. To the extent that there's any disbenefit in financial terms by reason of the existence of the lease, it's a disbenefit ultimately to the investors, but as one can probably appreciate, spread over whatever it is, 250 odd rooms. In financial terms, every quarter, the lease results in, I mean, frankly, a nominal adjustment to the investor's return. It's, you know, I don't know the precise figures, but it's very low sums of money that each month or each quarter are deducted from the income as defined. Moving then on to duomatic, I would just make one observation in response to the suggestion that there needs to be an overt objective act. I'm not sure it necessarily can be put that way, because of course what the authorities do disclose is that acquiescence is sufficient for duomatic. And that appears, I think, from all of the authorities. And so, and I would say that is what we have here, is where the board of Galliard Homes effectively acquiesces into Mr. Conway essentially taking all of the strategic decisions. Hence, we're back into the Cyban territory. Section 1157, my learned friend said that the judge hadn't made a finding of whether or not Mr. Conway had acted reasonably. I've suggested not, by reference to the relevant provisions of the judgment, but I think I would be constrained to accept that if this court concludes that there is no finding of whether or not Mr. Conway acted reasonably, realistically, I think that is something that would have to be remitted back to the judge. I don't see how this court can properly carry out that sort of finding, or de novo, really. Then moving on to some of the validity grounds. Could I just say something about my learned friend's point about if the underlease is gone, then South Bank is entitled to make use of the annex anyway because of the
You
title
certainly
matters.
can, but one thing for sure, if we get this far, we're not going to express any views on that.
No, and of course I wasn't inviting
No,
anyone to, and I certainly wouldn't invite anyone to express a view on that. But it does rather beg the question then, why on earth are we here? At least as regards grounds 3 and 4 and all the associated points. Because if they're right, bear in mind that the term of the underlease has come to an end. So it's not as though, I mean, it's within their gift. If they don't want to claim the benefit of the 54 Act and they just want to walk away from the underlease, they can. In which case, then one sort of begs the question, well, why haven't they? And it also, I mean, leaving aside the question that it makes a lot of the arguments academic, it also subverts and undermines South Bank's position on Clause 9. Because if it is the case that regardless of the lease, South Bank has always been able to make use of the annex, then most certainly there's been no loss, because they have some prior right to do what they claim that they are entitled to do. And it sort of ties in a bit with my Lord Justice Miles' exchanges with my learned friend, Mr. Porgadiri, I think, in the morning. And it's difficult really to reconcile Mr. Porgadiri's answers to your lordship and what my learned friend submitted in reply. They are different, exactly.
As I understood it, he was withdrawing that suggestion.
Well, yes, it's a sort of...
I mean, there is a question whether any of that has been an issue in this case.
It hasn't. And so then there might be question marks over, well, there might, anyway, but as I say, I don't think it's a matter that your lordships and your ladyship will ultimately need to be troubled with, because you're only seized of the grounds of appeal that are before you. But as I said, there is a sort of oddity in South Bank's approach in all of this. Dealing then next with estoppel, just to kind of make this point, estoppel works between the parties. It doesn't, the estoppel that I rely upon, it works between the parties. It doesn't bind third parties. And that's why section 44(5) and section 5 of the Companies Act and section 55 Section 52 of the Law of Property Act still has a role to play, because if there is some defect in formalities, that can have a big bearing on third parties and how they deal and how they can acquire interest and such like. So estoppel still has a role to play. But even if, let's suppose my learned friend is right, and that I can't use estoppel to override Section 52 of the LPA 1925, as he submitted a moment ago. So, in consequence, South Bank is entitled to argue that the lease is not effective at law. Okay, so I'll assume that that's right. Estoppel, however, still, in my submission, must then prevent South Bank from saying that nonetheless there is no lease in equity. Having taken, as it were, the formality point, the estoppel will most certainly be engaged at the next step of the analysis, which is whether or not, as I said, it is open for a tenant under what would otherwise be an equitable lease to deny the existence of the equitable lease, which is effectively what they're trying to do. Now, on the question of an equitable lease and the clean hands point, my learned friend made some submissions about the pleading in paragraph 21L. And he said it's never a good sign when relying on a pleading point. But this is important, and it's not arid, because as I took your lordships and your ladyship to yesterday, we pleaded positively in the defence that the leases would take effect in equity, and there is then a denial of that in the reply. And the rules of court, particularly in CPR Part 16, when you deny something, require you to give reasons, and that's so that when you go into trial, you know why it is that they are saying that you're wrong. And they have given specific and particular reasons as to why we are disentitled to leases in equity. And those reasons are effectively because we acted dishonestly and so forth. And the judge has rejected those reasons, and therefore it's not open on the pleadings for South Bank to say that there's some other reason why you should be disentitled to specific performance.
Sorry, go on.
So sorry, my lord.
Go on. You'll probably cover what I have in mind to ask you anyway.
It may be better if my lord asks it. So.
But I think Mr. Willen said, well, aside from the pleading point, this was covered in the written closing submissions.
I don't have them to hand. I have nothing, and I haven't looked at them, so I can't immediately say my learned friend is wrong. I'm sure whatever he says is absolutely accurate, and so I'm not in a position to say otherwise at the moment.
Since you may be surprised today, we're not going to give judgment today. I wonder if any bit of the written closing submissions that either side thinks bears on this could be sent in.
Yeah. Yeah, of course. Yes, we will. If this point was fully fleshed out in the written closings, then understood. But even then, in my respectful submission, that's not an answer, because this is one of those. This was one of those cases where everyone had prepared pretty lengthy written openings. There was a hard-fought trial over 2 and a bit weeks, and then written closings were deployed. I can't remember the precise chronology, but very, very close to the commencement of oral closings. And so I don't suppose anyone had a tremendous opportunity properly to digest and make submissions on the points in the written closings. And as I said,
they were very lengthy, I think.
They were. They were, I'm afraid. The judge was extremely indulgent in that respect, in allowing the parties to do that. But I said the reason, and I think this is particularly important, is because when one is considering clean hands, you have to think quite carefully about what breaches there are. And there are no breaches of fiduciary duty alleged against, or at least that could be maintained, against Mr. Conway in his capacity as director of Galliard Hotels and Lodgeshine, because certainly he owes no duties to, in that capacity, to South Bank. So the only sort of, as it were, material breaches of duty, insofar as any exist, and of course there have been no findings about that, would be vis-a-vis his directorship of SBHMC. And of course that might have a very big bearing on whether an equitable remedy would be available for, say, the grant of the lease, but possibly not for the grant of the underlease or whatever else the position might be. And so once you start unpicking at this point, you realise maybe actually it's a little bit more complicated than simply saying, oh, well, he's in breach of fiduciary duty and therefore you shouldn't get specific performance.
Yeah.
The last point I think I need to mention is the question of rectification. My learned friend said, as regards the underlease, he didn't understand me to take issue that South Bank can consent to rectification, but per section 1312, as regards the underlease, the party in possession is of course Lodgeshine, not South Bank. So my lords, my lady, I know you wanted less than an hour.
Yes.
That's what I've endeavoured to do.
Well, thank you very much. I don't think there are any more points to tax you with. I think you've all done extremely well to pack a great deal into less than 2.5 days. Thank you very much for your submissions. As indicated a moment ago, we will not be giving judgment here and now. You will, in the normal way, get the judgments in draft for you to correct our English and typing. That won't, of course, be an opportunity for you to re-argue the case. We'd be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, could we please have brief written submissions, and we would expect to deal with the points in the order that we make. Finally, although I'm sure everyone's well aware of this, I ought to remind you all of the importance attached to the embargo. I think it's the case we've already had a list of those to whom the draft judgments should go. Should it turn out that we haven't, then can we please have that? But if you think of anybody extra, you obviously need to come back to us rather than merely distributing the judgment to that person. But anyway, thank you, those with speaking roles and those without, very much for your assistance in this difficult case.
Court rise if able.